Hello, this is Matt on the Moon Lambo channel. The SEC loses to Ripple again. A huge blow has been dealt to the SEC by Judge Sarah Netburn by denying a recent motion. And I'm going to share with you in this video specifics of this. And I've got opinions from, I believe, 3 attorneys in this video, and this could be a huge deal. This can, in a meaningful way, contribute to a slam dunk win for Ripple, as I will articulate. So, plenty to talk about in this latest Moon Lambo Hot Jam. But before we go any further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering financial advice, and you should not buy or sell anything because of anything that I say, alright. I'm just an enthusiast who makes YouTube videos all up on the internet because it's a fun thing to do from time to time. Okay, all the damn time. I'm a little obsessed. Alright, so check this out. This is the actual documentation, which, by the way, just came out a couple hours ago on a Sunday morning, no less. How about that? So here is what the judge said at the very top. The Securities and Exchange Commission seeks an order compelling Ripple to produce all communications constituting, transmitting, or discussing any legal advice Ripple sought or received as to whether its offers and sales of XRP were or would be subject to federal securities laws. The motion is denied. And I gotta tell you, I love that it's in all caps here. In particular, when it's in Ripple's favor, just that extra little oomph. And I know it's not unique to this, I understand that, but still I like that. Because you know what, as far as I'm concerned, the SEC can suck it. Eggplant emoji. Eggplant emojis all over. And so at stake in this motion was whether or not private communication between Ripple and their attorneys would be protected under attorney-client privilege. And these are important documents dating back to 2012 and 2013. And so XRP community member and attorney James Filan wrote the following. Breaking, Judge Netburn denies SEC's access to Ripple's legal memorandum, dealing huge blow to SEC. Now, let me assure you, and you may be aware of this already, attorney James Filan here does not engage in hyperbole. The fact that he wrote huge blow is significant. He doesn't write that every single time that Ripple wins a motion. Here's an opinion from attorney Jeremy Hogan. Judge denies the SEC's motion to compel production of Ripple's lawyer opinion letters. Very important because the judge states Ripple's subjective beliefs in XRP are not relevant to the fair notice defense, blocking the road the SEC wanted to use to fight the defense. And so check this out. Look, this is huge for Ripple's fair notice defense. And just to be clear, so that everybody knows what we're talking about when I say fair notice defense, also sometimes called the due process defense. It's this idea that, frankly, because Ripple's been around and XRP has been around for the better part of a decade. XRP has been allowed to be traded in the United States and globally, of course, ever increasing. In fact, it's been adopted at an exponentially increasing rate. The SEC has been aware of what Ripple has been doing this whole time. And if Ripple was doing something wrong, the idea is you should have told us sooner. We should have known. It's just this idea of like the average person, a person of average intelligence, could they have reasonably known that what they were doing would have be deemed to be illegal by the SEC? And here I think the answer is clearly no. There's no way Ripple could have known this for a ton of reasons that I've been articulating on this channel over time. And so this fair notice defense, the fact that the SEC didn't let them know that they shouldn't have been doing what they're doing, that defense has real teeth. And so, thanks to this SEC motion being denied, the one here right here today, denied by the court, there is now no way that the SEC can use information protected by attorney-client privilege to argue that Ripple did know what it was doing with XRP was illegal. So remember, if Ripple's right to use the fair notice defense is upheld by the court, this is a huge risk to the SEC. Because if it is ruled that Ripple did not have fair notice from the SEC, then the case is over and Ripple wins. Period. And that's not speculation on my part. That's how the law works. So there's a tremendous amount at stake here. Now, for the SEC specifically, if things actually went that route, and Ripple wins on its fair notice defense, the SEC is in a heap of trouble because that sets precedent. And if they want to go after any other entity that's, just imagine any number of companies that are perpetuating, maybe created a cryptocurrency, whatever, and there are tons of them out there. If they've been around for some time and no action was taken against them for years, frankly, they can use the same argument. Precedent will have been set, and so the SEC's power will have been weakened. And so you got to sit here wondering, is this a risk that the SEC is going to be willing to take? Because if they lose this, if they lose on that front, their powers diminish. So might they just settle outright instead? And that's the speculation. That's a huge part of what the community's been talking about here. And so somebody named XRP Goat responded to that last tweet from Jeremy Hogan I read just a moment ago and said, would a fair notice settlement give XRP the clarity it is looking for? And Jeremy Hogan said simply, yes. And I'm going to talk more about that a little bit later in the video, but yes, that's a firm yes. And then somebody asked attorney Jeremy Hogan the following: What are you batting on these predictions? So he's talking about the predictions for how the motions are going to play out in the court. We might have to create a trading card for you. And Jeremy Hogan wrote the following: I've been right so far except on the MOU issue, but I was right on that before I changed my mind and was wrong. So even when I was wrong, my past me was right. Boom. Smiley face. And that's true. So as far as the MOU, you may recall, I'm not going to explain it in this video, so sorry if you don't know what it is, but it'd be way too much. It's not the focus of the video, but I will say the only reason that as I recall anyway, that he changed his mind about whether or not Ripple would win on that motion is because the court was taking so long to get a decision. He thought, okay, well, maybe this is something outside of precedent, and it's been just so long that, yeah, I guess it seems more likely that Ripple actually probably is going to win on this, and then they actually lost. But really, what is that, like 4 or 5 motions to this point, and SEC has won one of them, and then Ripple the rest. And so the SEC, as I've said before, they're just making all sorts of bogus nonsense claims and just seeing what will stick. And to this point, almost nothing is stuck. They are not in an ideal position here. Here's attorney John Deaton, another XRP community member. He wrote the following, and this was on May 21st, exactly on this topic before we got today's ruling on this motion. He wrote the following. Let me start here. The SEC argues they should get the entire legal memos because Ripple has asserted a fair notice defense, but that's not how it works. Ripple only asserted it because they were sued. If the SEC is correct, then the attorney-client privilege could be pierced anytime a defendant claims lack of knowledge. The attorney-client privilege is sacred, up there with spousal privilege and priest/pastor privilege. The SEC should lose the motion based on the argument that Ripple has raised it. But if Ripple shared the legal memos with third parties, i.e. to VC investors, before they would invest, then Ripple is likely to lose the motion and probably should under the law that I've reviewed. And so that was my only concern, because there does seem to be some evidence that Chris Larson and maybe some others actually had shared some legal memos, which would, from a legal perspective, my understanding was that it may have resulted in them basically saying, yes, we're willing to forego our attorney-client privilege because we've shown it to people, third parties. And so I thought, well, I don't have a court background. And even the attorneys here talking about this, weren't sure if that would be enough for Ripple to actually lose the motion here. Turns out the answer is no. The SEC lost the motion. So again, sucks to sucks. Sucks to suck, bitches. Almost said that right. Moon Lambo, so cool. And then you wrote here, this is today, just an hour ago. Below is my position before the decision. The only way the SEC could get Ripple's legal advice memo was if Ripple shared it with others. The SEC's argument that Ripple waived the privilege because it asserted the fair notice defense was never going to be justifiable reason for penetrating the attorney-client privilege. This alone isn't going to force the SEC to settle, but it's another public loss for the SEC. Now, here's a tweet from attorney Jesse Hines, another member of the XRP community, wrote, "Not surprised the SEC won't get copies of legal advice that Ripple received from its attorneys. No real effect on the issue in dispute, but a good ruling." But he added to that. It changed, well, not that he changed his mind. He he regrets the way that he worded it. And so he followed up just a little bit later and wrote the following. Should have chose my words more carefully. Forgive me, it's Sunday morning. There is an effect on the case, specifically the fair notice defense. It just doesn't have an effect on whether XRP is a security. And so this is why this is such a big deal. The fair notice defense, again, if this stands and is upheld by the court, my gosh, this is over. This is a big, and so this is another, the ruling of this motion today is another thing nudging us closer to that potential outcome. So we don't know for sure if that's going to happen, but there's reason to be optimistic. This absolutely is a huge blow for the SEC. Here's another tweet from Jesse Hines about the fair notice defense. He wrote, "Here's a fun thought experiment to ruin everyone's Sunday. If Ripple were to win on its fair notice defense, that wouldn't actually clarify whether XRP is a security or not. All it would clarify is that the SEC couldn't fine/punish Ripple for its past sales." Now that's true, but if you look back to what Jeremy Hogan wrote, where did I highlight it? Maybe it was here. Yeah, so he was asked, Jeremy Hogan was asked, would a fair notice settlement give XRP the clarity it is looking for? Jeremy Hogan said yes. And so he's right. They're both right, frankly. XRP wouldn't technically be declared not a security, but it would have legal clarity because you can't go after Ripple again for the same thing that you already sued him for and lost. Ripple would be in the clear, and who else would you go after for claiming that XRP was sold as a security? You already said Ripple did it. It's like, we're going to sue Ripple, but then we lost this case, and now we're like, oh, wait, but there's this other entity over here that was doing the same thing the whole time. Like, no, of course not. And so, effectively, you couldn't go after it ever again. And so, even if it's not declared ever that XRP is not a security, and that may be the case, that would be fine for XRP holders. We can move forward. Ripple can move forward. We don't have to worry about it anymore. And that may be the outcome. And I'll tell you what, as much as I'd prefer in a general sense to have clarity for the whole crypto space, I would take that as a win. And the SEC would keep being a bunch of asshats, and they would continue to sue everyone into oblivion while not providing sufficient regulatory clarity, and it'd just be messy forever. And that's what the SEC wants to do. Well, that's unfortunate. Because I hold a couple dozen cryptocurrencies, and I'm just thinking, okay, what else do I hold that the SEC is going to come after next? So yes, as an XRP holder, I'd prefer supreme clarity overall, but in lieu of that, yes, I would take the fact that at least XRP, which happens to be my largest crypto holding, at least you can't go after Ripple and ruin the adoption of XRP within the United States or globally for that matter. So there we are. Good news all around. Let me know what you think about this below, but I'm feeling pretty gosh darn hard this morning. I'm feeling pretty gosh darn good. I'm going to go to bed. I didn't get much sleep, actually. I actually woke up and I checked my phone and I saw this. I was actually going to go back to sleep, but I was looking at my Twitter feed and I was like, okay, well, I gotta talk about this. Plus, I couldn't go back. I couldn't fall back asleep without covering this. So I am going to go back to sleep though now, at least a couple more hours. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.